Today on Bench Briefs, we're looking at a fascinating case from the Federal Court of Appeal that dives into the complex intersection of Aboriginal law, land management, and jurisdictional questions. The case is Tsawout First Nation vs. Claxton, decided in 2026. It raises important questions about who gets to decide disputes involving land on reserves, especially when it comes to landlord and tenant issues. So, what's this all about? The Tsawout First Nation, an Indigenous community on Vancouver Island, brought a judicial review application challenging a decision related to the management of land under their control. The dispute centered on a landlord and tenant matter involving property on reserve land. Essentially, it was about who has authority over real property disputes in this context. The Tsawout First Nation questioned whether the federal court had jurisdiction to hear the case, given that it involved reserve land and Aboriginal rights. At the heart of the case was a tricky question. Does the federal court have the power to review decisions about real property and landlord-tenant issues on reserve land, or is that jurisdiction reserved for other bodies? This touches on a broader issue in Canadian law about how federal, provincial, and Indigenous laws interact when it comes to land management on reserves. The federal court's jurisdiction is generally limited, and cases involving real property on reserves often raise complicated questions about which court or tribunal should be involved. Another twist in this case was that during the proceedings, questions arose about whether the matter had become moot. In legal terms, a case is moot if there's no longer a live controversy or if the issue has been resolved in some other way, making a court's decision unnecessary. When a case is moot, courts often decline to hear it because their rulings would have no practical effect. So the court needed to decide not only if it had jurisdiction, but also whether it should proceed with the judicial review despite the possibility that the issue was moot. To unpack this, let's start with the jurisdiction question. The Tsawout First Nation argued that the federal court did have jurisdiction because the matter involved federal law and Aboriginal rights. However, landlord and tenant disputes generally fall under provincial jurisdiction, and courts have been cautious about overstepping when it comes to real property on reserve lands. The court had to carefully consider the scope of the federal court's powers and how they apply in this unique context. On the mootness issue, the court examined whether the dispute was still live or if circumstances had changed so much that a decision would be purely academic. Even if a case is technically moot, courts sometimes decide to hear it if the issue is of public importance or likely to recur but evade review. This public interest exception helps ensure that important legal questions don't go unanswered just because the specific party's situation has changed. In the end, the Federal Court of Appeal provided guidance on both points. It clarified the limits of federal court jurisdiction over real property disputes on reserve lands, emphasizing the need to respect the division of powers and the unique legal status of Indigenous lands. At the same time, it addressed the mootness issue, explaining when courts might still intervene in cases involving Indigenous land and governance, even if the immediate dispute has changed. Why does this case matter? First, it highlights the ongoing challenges in Canadian law about jurisdiction and governance on reserve lands. Indigenous communities often manage their own lands according to their customs and federal statutes, but when disputes arise, it's not always clear which court or tribunal should hear them. Tsawout First Nation versus Claxton sheds light on how courts navigate these tricky waters, balancing respect for Indigenous self-governance with the practical need for legal clarity. Second, the case underscores the importance of the mootness doctrine and its exceptions in judicial review proceedings. In Indigenous law, where issues can be complex and evolving, courts must decide when it's appropriate to step in and when it's better to let matters rest. This case helps define those boundaries. Finally, Tsawout First Nation vs. Claxton reminds us that legal questions involving Indigenous land are rarely straightforward. They involve layers of history, law, and politics, and courts must carefully consider all these factors when making decisions that affect Indigenous communities and their rights. Thanks for listening to this episode of Bench Briefs. Join us next time as we explore more cases that shape Canadian law and impact the lives of people across the country. Until then, take care.